Google had to replicate the syntax and the structure of the API declarations exactly, because obviously they have to match, right? When you make an API call, you have to make the call to the right function. If you don't have the function's name, declaration, etc., exactly correct, including case, the call is going to fail or go to another call or error out or something, right? There's a petition for a writ of certiorari in the Google v. Oracle case.
Yes.
This is 343 pages long, so we're going to just together this morning try and figure out what in the world they think they have grounds for in this petition. Hopefully they've summarized it for us.
I want to know how that's even possible, because writs of certiorari have page limits.
Yeah, for some reason, yeah, I don't know. Well, let's see here, because they're saying here that they've written the whole thing within 33 pages, so that sounds about right.
Yes.
And then the table of authorities, all of their cases are attached, it looks like.
Why would you do that?
Pardon your eyes for a moment as I just quickly scroll through this. What happens when we get to these upper pages here? It looks like they've attached all the below opinions that they thought were... Yeah, these are all of the below opinions that they feel apply. They're all attached. That's what it is. So it's actually 33 of pages, and it's 33 of these small pages too. The page is literally that big. Questions?
Yeah, it's on a weird page size. I forget even what it is because we actually physically printed it.
Right. So this, not to get too sidetracked here, but this is a thing. When you go to petition the Supreme Court for certification that they'll hear your case, which is called a petition or writ of certiorari, you have to abide by their formatting rules. You always have to abide by a court's formatting rules, but the formatting rules for district courts, pretty much any lower court or normal court, they make normal sense. 8.5 by 11, 12 point times New Roman, 1 inch, 1.5 inch margin. Sometimes that's different. And really the biggest problem you'll have is when you have to print out multiple copies or when you have to send a courtesy copy by mail or something. That's really the most complicated part of at least federal district court for me. When I was doing local common pleas court stuff, every county's different, and some of our counties in Pennsylvania are still in the dark ages, so you put things on paper, fax things in with a 14.4 kilobaud modem, because we're still using that these days over a phone line. Wow. Anyway.
The Supreme Court is 6 1/8 by 9 1/4.
Yeah. And
Why?
So no printer prints that. So you have to hire a company to print either using a special printer and special paper, or there's actually a couple articles that have been written about this. You buy what ends up being a much cheaper large format printer and then just print on larger pages and cut it down using a binder or slicer or whatever. And
That'll work.
The company that was going, this was about 10 years ago I read about this, or maybe less than 10. It was when I was still in law school. The guy who had to petition for a writ of certiorari, he was just a solo law firm, didn't have the resources to hire a company to do it because the company wanted upwards of $10,000 to print and format it properly, his entire packet to the Supreme Court. I believe they need 23 copies. Is that correct, Kurt?
That sounds right.
So they need to print and bind 23 copies of your entire brief in this proper format, this odd format, which means spending time on it, like by hand. And so they wanted $10,000. He was able to do it for $3,000, which included buying the printer, which was most of the expense in the first place. So still $3,000 just to print the petition for a writ of certiorari. So that's what we're talking about here. And of course, the Google Oracle case, I guess a little more background, is try to get on the same page here, because I actually haven't, Your Honor, I haven't prepared for today's hearing very well. I was busy this week, so we're doing all this kind of on the fly. The Google Oracle case was about the copyrightability of application programming interfaces. If I recall correctly, Oracle bought the properties underlying Java, and Google wanted to make its own Java. And we use a lot of Google's JavaScript libraries and such. And I'm assuming other organizations use a lot of Google's version of Java. And normally the code is the only thing that can be copyrighted and not the functionality. So Google can make its own compatible version of Java as long as it's not copying copyrighted code. It can make its own code, do its own thing. The functions can be the same as long as they aren't copying protected elements. And this starts to get a little weird. So be patient with me here. In code, there are variables and constants, which would sort of be like variables, but they just don't change. And many other things, functions, structures, objects, can all have names. And the developers or programmers can use various naming conventions that have been established as sort of a good idea. Integers get an int in front of them, or et cetera, et cetera, et cetera. When to capitalize and all that. Well, some of this has to reach some kind of level of creativity, right? At some point, when you name something, it goes from int input might not be very copyrightable, but if you added something to it, int user input when the user does such and such, at some point this becomes protected. And somebody correct me if I'm wrong, because I've not read this 343-page document yet. Maybe we're going to have to cut all this out because I've got this completely wrong. But my understanding is that the big copyright issue, or the big issue in Google v. Oracle, was that the appeals court said, I'm guessing this is Ninth Circuit Court of Appeals, right? Said that the Java API from Oracle does contain protectable elements that Google copied when they made their own API, because Google used the same naming conventions and the same variable names and function names and things like that. And that means basically that no one can make their own API with something. There's like this slippery slope argument that developers are concerned that they're never going to be able to make their own API again. It means that you can't copy their conventions, their names, and anything that it's easy for me to say, anything that's copyright protected. Well, what is that? That's what we're talking about here. Kurt, are you with me?
Am I close? Correct.
Okay.
Yeah, you're right. The issue is it's essentially the copyrightability of the API for Java. So if you want to write a program in the Java language, then you can use their application interface to make those calls. And the idea is whether or not that is copyrightable or not. And 17 U.S.C. 102 suggests the answer is no, because it would qualify as a method of operation, but that's the dispute.
Yeah, let me go one step further. It's not if I'm a user who wants to use the Oracle Java API. It's if I need to make a copy of it and call it my own. Normally, the functions of an API are not copyrightable. Functional things, you apply for a patent. And if there's no patent, or if a patent has expired, or if it's not novel, etc., it's not patentable. But copyright would not be able to be used. So it's specifically when the certain elements, certain names or other conventions in the code itself can be copied. I'm really trying to grasp at what the exact scenario is, because the exact scenario that really I see here is Google made their own Java version so that they didn't have to either license it from Oracle or didn't have to be subject to Oracle's terms or something. Can someone out there answer why Google may have made their own API in the first place, and why the developers and others that are making the slippery slope argument are so concerned that they can't now make their own API?
Well, I mean, the reason to make it is because if you use theirs, it comes with an end user license agreement like any other kind of software. So that comes with a whole bunch of conditions you may not want to use. So you say, well, rather than me use your thing, let me just invent another thing that does the same thing, so I don't have to use your end user license agreement. That's the rationale.
Yeah. This starts off The Copyright Act provides that while original works of authorship are generally eligible for copyright protection, in no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied. The Act also makes clear that fair use of a copyrighted work is not an infringement of copyright. As is relevant here, software interfaces are lines of computer code that allow developers to operate pre-written libraries of code used to perform particular tasks. Since the earliest days of software development, developers have used interfaces to access essential tools for building new computer programs. Contravening that long-standing practice, the Federal Circuit in this case held that both a software interface is copyrightable and that a petitioner's use of a software interface in a new computer program cannot constitute fair use as a matter of law. The questions presented here are whether copyright protection extends to a software interface, and whether, as the jury found, petitioner's use of a software interface in the context of creating a new computer program constitutes fair use. Well, that just clears it right up for everybody, right? Now I know exactly what's going on here.
I understand what that means, but yeah.
Is it Kotlin they're talking about, the programming language? Okay.
Yeah, so they basically threw in a patent claim that was pretty garbage just to be able to get to the Federal Circuit. Because the case shouldn't have been decided by the Federal Circuit anyway, because copyright issues don't go to the Federal Circuit. But they threw in a patent law claim so that the Federal Circuit would be deciding this issue rather than the Ninth Circuit, where it should have been decided, which would have gone the other way, I'm sure. So the whole thing is weird. And I just think it's yet another opportunity. I think they're going to grant cert, and I think they're going to reverse, because the Supreme Court loves to bash the Federal Circuit around, and this is another opportunity for them to do it. So I think the likelihood of them granting cert is high.
This case has been aptly described as the copyright lawsuit of the decade. As it comes to this court, this case presents two exceptionally important questions concerning the copyrightability and fair use of software interfaces, lines of computer code that are necessary to allow developers to obtain pre-written libraries of code used to perform particular tasks. I'm assuming that this is just obtuse language that is being used to refer to, things that developers would normally do, calls to various functions, calls across program to program, etc. The first question is whether copyright protection extends to a software interface. The court granted certiorari to resolve a closely related question in Lotus Development v. Borland in 1996, but the court deadlocked 4-4 on that question after oral argument. The second question is whether, as the jury found, petitioner's use of a software interface in the context of creating a new computer program constitutes fair use. The lower courts are badly in need of guidance on how to apply the fair use doctrine in the context of computer code. This case involves a high-profile dispute between two leading technology companies, petitioner Google and respondent Oracle. Sun Microsystems originally developed Java, which includes the free Java programming language, which Kotaku is saying is not free anymore. Somebody follow up on that. The software interfaces at issue are part of the Java language application programming interface. Sun encouraged developers to learn the Java language by touting the ability to use software interfaces, known as the Java API declarations, to access pre-existing libraries of code used to perform particular tasks. The interfaces thereby facilitated development of programs in the Java language. Google used some of the Java API declarations to build Android, a revolutionary platform for modern mobile devices such as smartphones and tablets. Google incorporated those declarations to allow developers to write applications for Android using the Java language. Sun originally applauded Google for using the Java language, but after Oracle acquired Sun, it sued Google for copyright infringement. After years of litigation, the Federal Circuit, which had jurisdiction because of Oracle's initial assertion of now dismissed patent claims, has twice reversed judgment in Google's favor. It has first held that the Java API declarations are copyrightable and then overturned a jury's verdict that Google's use of the declarations constituted fair use. The Federal Circuit thereby deepened the acknowledged conflicts among the courts of appeals concerning the application of the Copyright Act and the merger doctrine in the context of computer software. Google has never disputed that some forms of computer code are entitled to copyright protection, but the Federal Circuit's widely criticized opinions in an area which that court has no specialized expertise go much further, throwing a devastating 1-2 punch at the software industry. If allowed to stand, the Federal Circuit's approach will upend the long-standing expectation of software developers that they are free to use existing software interfaces to build new computer programs. Developers who have invested in learning free and open programming languages such as Java will be unable to use those skills to create programs for new platforms, a result that will undermine both competition and innovation. I don't know, those aren't strong copyright arguments undermining innovation and things, right? That's not what the basis of copyright is.
Not really, no.
That, people are going to be out of work, or people are going to have useless skills that they've now learned. Those are the pitfalls, and I'm really not trying to get down on anyone here. Those are the pitfalls, though, of learning a free language, right? That it could get bought by something, or if the license is written in a restrictive way, that you could end up owing them money. A lot of licenses these days, for like Unity and such, you're allowed to release your game or make your game for free, and then only after a certain size of the company or number of sales or whatever, then you owe licensing fees, and that's fine. But okay, so when you learned Java and all that, you thought it would be free forever, and now we can have a big argument as to whether or not Oracle is right to try and charge for it, or et cetera, et cetera, et cetera. Google doesn't appear to have been using their own program to interface to Sun's Java. They appear to have copied some of Sun's code. Follow me here. Somebody correct me if I'm wrong here, but what is not, it's not that Google is acting as a client interfacing through the API to a Oracle or Sun server of some kind. Google is making their own version of Java in an Android context, so that when a program is written in Java, whether it be Sun or Google, it can be either compiled or because Java doesn't, it's a runtime compiler. It compiles at runtime. So they would have to have some kind of runtime compiler basically in Android. And instead of licensing Oracle's Java, they made their own version of Java.
They've made a programming language that can interface with JVM API. That's what they've made. So, like, it can use all of the same stuff as Java uses, essentially.
Okay. Yeah, that's a complicated question, because I agree that at some point there's some kind of protection for the code itself. But then when you are simply interfacing between programs or parts of programs, functions, etc., that's more functional. That's more of a process. Not copyrightable, in my opinion.
It's a very interesting issue. I think the petition is well set up. I agree with the framework. So I think the Supreme Court is likely to grant cert, and I kind of hope they do. So we'll see.
So throughout a lot of this, I'm seeing kind of an overlap between things that are functional and things that are creative. So creative would get copyright protection, and that copyright protection lasts a long time compared to something that's functional and is a patent. Because Kurt, it's 8 years for a patent?
20.
20? Compared to copyright, which is, decades and decades after you die. And so I'm, I guess, in my own head trying to tease apart what's functional and what's creative. Even if you used creativity to make something that's functional, it's still, I see a gray area here. I don't know if anybody else sees it.
Yeah, I do. I think it's dangerous to call this copyright, because like that's exactly what patent is for, right? Is like making it easier for people to create new technologies that they wouldn't otherwise be able to under copyright. Like that's why patent is separate from copyright. Am I wrong?
Yes, you're not wrong. Patent and copyright are meant to serve two different public purposes. The believe it or not, the unspoken or unfocused on or a little focused on part of this is that at the end of the 20 years for patent, assuming no renewal or whatever, the patented information is now free for all. And everyone has this information. Technically, the people had the information at the beginning when the patent was applied for. They just aren't allowed to use it for a commercial purpose or et cetera, et cetera, et cetera. Copyright obviously has this much longer term. And so there must be a very well-defined line between them so that we don't apply copyright law to protect something that should have been protected by patent for a much longer period of time. There's lots of examples of companies trying to do this too.
Yeah, and I don't think it's fair for Oracle to have Disney level protection on their Java code for this. I think like it is absolutely an innovation, Java, and you can't like. I don't think that this is a copyright issue. I just don't like. I don't think it's.
So let me just finish this summary here because there's a few things in here. So Google wanted to create their own Java compatible base code in Android so that developers could use their existing Java language skills to create Android applications. So Google had to replicate the syntax and the structure of the API declarations exactly, because obviously they have to match, right? When you make an API call, you have to make the call to the right function. If you don't have the function's name, declaration, etc., exactly correct, including case, the call is going to fail or go to another call or error out or something, right? So they had to replicate those exactly, and any change to those declaration would have prevented. So this is like cogs coming together in a gear. They have to mesh the gears properly. And they said that they ended up with 37 Java API libraries that were key to mobile devices, and Google wrote its own implementing code, tailoring the code to accommodate the unique challenges of smartphones. But because some of the code has to match and mesh with the other half of the API or the other half of the double helix, metaphorically speaking, 3% of the code is the same across the 37 libraries, and that results in the alleged copyright infringement. In total, the overlapping code represents less than 0.1% of the 15 million relevant lines of code in Android, according to Google's petition. So without going further and further into that, that's what that's about. It's the fight over whether literally making API calls, I'm guessing, to existing Oracle libraries because they have to use the same names in order to make the calls. Is that copyright infringement? It doesn't sound like it is to me. It does sound like it touches on a copyright issue, so I can kind of understand why it would be confusing. And there's obviously a lot of money at stake here, because if Oracle is suddenly due licensing fees from every Android device on the planet.
Oh, yeah.
That's one of the things I don't like about software patent cases, is it's very easy for me to go onto my computer and make a smart Excel spreadsheet or whatever. And here's one for you. Maybe I want to include a bit of code on my website that makes a video file pop up. You go to USA Today or another news website, and half of them have these annoying autoplay videos that pop up, and some of them even have autoplay videos that pop up with audio already running, like unmuted. Let's say that you wanted to do that on your website. You go to leonardjfrench.com and something pops up with Leonard with a Lawful Masses video about some service that I offer or something like that. Well, you might think that you could just go write that code, and you really should just be able to go write that code. It's JavaScript, whatever, embed video and all that. Well, there's a couple things that have happened. One, some people have actually committed copyright infringement by finding another website. And since when you go on to USA Today or whatever, you have to load the code onto the client, and then your web browser runs the code. If it's JavaScript or Java, it's real-time compiled and all that. When that happens, you have the code. So some people just copy the code, or their developer copies the code and then puts it on their website. Well, there's a company that goes around and sues people for that. So that's one thing that happens. Second, someone might come along and say that they own some proprietary technology in the form of a patent on the method or something for displaying a video on an advertising medium electronically through whatever. And it might be valid and it might not be valid, and it might even be from 10 years ago or 18 years ago or something. And you're going, how in the world is this relevant? And there are organizations that have legit claims, and then there are organizations that have an otherwise invalid patent, but are just going around and trying to collect as much money from it before someone either gets it declared invalid or it expires, otherwise known as patent trolls. Major organizations that do this as their entire focus, to just patent troll. No other purpose other than to find patents that can be exploited by them and then litigate, or should I say threaten to litigate. Any more thoughts on Google v. Oracle? Did we kill this one sufficiently? We could go over the next 328 pages.
I guess I'm just wondering what Blackleaf thinks of it in a little bit more detail, because this is your home turf, isn't it, Blackleaf?
I mean, software patents is my home turf, yeah. So, I mean, I think that it seems the question is essentially, is it a functional thing or is it merely an expressive thing? That's the fundamental question. And it seems to me it's functional. So it seems to me it's patent. And to the extent that you're having to use the specific labels because you want the calls to work for the interoperability, that seems functional. I'm not using that word because I'm plagiarizing. I'm using that word because if I don't, it literally will not work. So that's functional. So I think the lower court got it right. I think the jury got it right. I think the Court of Appeals for the Federal Circuit got it completely wrong, because they are IP maximalists and they love all the IP and they want to protect it from everyone forever. And I think the Supreme Court should grant cert and should reverse. And if they do, I will go to it in person. And also, if the Lawful Masses wants to give me like $5,000, I could file an amicus brief. That could be fun.
Does it cost money to file an
the printing again?
Oh, right.
Printing. Yeah.
I definitely feel like sometimes the court system is a good 20 years behind in adopting technology.
I mean, it makes zero sense. We could just have e-filing, and it could be like 8.5 by 11 paper that everyone else literally uses. I mean, when they turn into a PDF, they turn into an 8.5 by 11 PDF. So I don't understand the Supreme Court sometimes, but they have their own way of doing things for some reason.
All right, so that's our show. Thank you very much for joining me. I am Leonard French, your favorite copyright attorney, here as usual to discuss the law with my lawful masses. We still use patreon.com/ljfrench as our primary method of financial support. The numbers came in from last year, and Patreon has a very clear win in the revenue stream. YouTube wasn't even close to the amount of money that Patreon generated. So congratulations, Patreon supporters. You've beaten YouTube, and we're making these videos for you. Now, I've been making videos for my Patreon supporters for the past year plus, as opposed to making videos trying to accomplish YouTube views. And the point is because Patreon supporters are the main audience. They're the ones who are supporting the thing and want to see the thing the most. And so we prioritize our content for the supporters. So the supporters have a channel on my Discord, as well as access, of course, to the Patreon private stuff, which we don't release too much patron-only stuff. If you guys want to see more of that, let me know. We'll try to come up with something. It's not like I can show you my day-to-day, because a lot of what I do is confidential with clients and things, but we can try to come up with some things. So for the month of January, our Patreon supporters are as follows. At the $50 level, thank you to Jonathon Doe, John Steele, Gavin Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Michael Pearce, Terry Crisp, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, and Sean McNamara. And the $5 plus supporters, there are about 200 of you, are scrolling on the LED panel behind me and on the crawl of the video when Brandon edits them down. So thank you very much for joining me. Do I prefer Twitch subs or Patreon? I think Patreon takes less money. I think Twitch takes a higher percentage. What I haven't figured out is how to put Twitch subs into the Patreon. Like, I mean, obviously I can figure out how to do it. We haven't set up the system to do it yet. So if the Twitch supporters want to be in the list of sponsors, let me know. We'll figure out a way to make that work. And I'm assuming we're going to have a sponsus.org support page here at some point as well. And so all of that will have to get integrated. So there will be other support options as well, from Sponsus, from either PayPal or Twitch, and of course through Patreon. And YouTube, conspicuously, has not turned on our paid subscriptions feature on YouTube, even though it's only supposed to be a 30,000 subscriber threshold, and we're at 100. So I don't know what's going on there. Anyway, so thank you all for joining me. I'm Leonard French, your favorite copyright attorney, and I will see you in the videos that drop. Love you all. Bye.